Let's look at the definition for arrearage. Arrears in child support is a term that refers to the past due child support owed to a custodial parent, or the mother and the father. Sometimes the Office of Child Support can assign the arrears back over to the state for repayment of any sort of public assistance or custodial parent that received public assistance. In addition, the child support arrears remain payable until all the back payments have been collected. And some states will convert the arrears into what is called a money judgment after 10 years. Now, all of this is found under the statute 45 CFR 303.100, which is called Procedures for Income Withholding. That is, that majority of the child support collections and the collection of arrears falls under what is called income withholding. So let's now look at the understanding of arrearage, or the short form is called arrears. We will use the case Dox versus Tynan, which I mentioned earlier in the video. So to start, the father must determine whether he has or owes any amount of arrears, and the correct amount. Arrears can build up very quickly, takes a few months, but it could take over years to eliminate. If your child support order, the underlying order, is terminated, you still owe the arrears to the state or to the agency. The state, your home state, will garnish the wages from your income and apply what is called tax refund offset. And the agency can charge interest on the arrears. Filing bankruptcy does not remove the child support arrears. Similar to student loan, you have to pay it back. If your child or children are emancipated under the child support obligation, the arrears still remain in effect. That is, it takes forever to pay the balance off. In some states, in some programs within the states, they offer what is called a negotiation of settlement with the arrears. Now, in our research that we found, less than 2% of state programs offer that services or offer this sort of passage to reduce the arrears. And all this information we found when we researched the Dox versus Tynan case. Let's look at the fundamental now of the arrears and the collection of arrears. On the screen, I have a chart called the monthly total for certified arrears. That is, arrears that they have confirmed. Now, since 2003 until 2014, the arrears, child support arrears, grew from $60 billion a year to $120 billion per year. Extrapolate that to 2018, you can add $2 or $3 billion to that.
Hey, it's Grant, and the little thing I love about the Chick-fil-A.
The TANF, or the Temporary Assistance for Needy Families, is a classification for what is called the Title IV-A program or the welfare program. Now, the source for this chart is the Federal Office of Child Support Enforcement. This points out the reasons, the fundamental reasons why the courts are reluctant to reduce the arrears. It's because it's a profit motive for both the state and a profit motive for both the agency. Why would you eliminate your profit?
Big business.
Let's take a side note now, and let's look at a class action suit for arrears. This is a case of Lero versus Department of Human Services, or the Office of Child Support that's inside the Department of Services. Ms. Lero decided to bring what is called a class action lawsuit against the agency, whereas she wanted them to collect the total arrears for the services. The justice says, under the Blessing versus Freestone requirement, there is no private right for a mother to force the agency to collect arrears. Again, as we review that case, the 1983 law does not permit what is called a private right for individuals, either the mother or the child, because the mother signs over her rights to the agency. Furthermore, for this lawsuit, the justices says that the Title 4D program is between the state and the agency and the federal government.
The Title 4D.
Interest on the arrears. The arrears has what is called, they've attached interest, and we will look at some of the interest rates later. But for now, for the child support agency, they treat fees as income, and that is under statute 45 CFR 304.50. Any fees collected by the agency under the Title 4D state plan, or any interest or income earned on a quarterly basis, is kept by the agency. Again, this is one way that the agency collects fees for administering the program within the state. Also, if the Office of Child Support assigns the arrears rights to the state also can add their own interest on top of that. So in essence, everyone's making money off the backs of fathers, or as I say, putative fathers, or fathers who signed the agreement for the acknowledgement of paternity. So let's turn our heads now to what is called the enforcement of arrears. Now that we understand how they make their money and why they want to continue to make their money, how do they get compliance or enforcement? This falls under the statute of 45 CFR 303.51. The first enforcement is called suspension of driving privileges, or your driver's license. So here are the guidelines. After 4 months of accumulated arrears, the Office of Child Support will issue what is called an automatic order to the Department of Motor Vehicle to suspend your driver's license. So for example, if you were charged with child support of $100 per month, or $100 per week, so that's $400 per month, and 4 months have elapsed where there are missed payments, the total amount of that would be $1,600. So if you're in arrears for $1,600, then an order will go out for an automatic revocation or suspension of your license. In addition, it will also suspend your state or professional's license as well under the same provisions.
Ain't that crazy, y'all?
Now, all the staff members who handle this process are all acting what is called under the color of law, whether they're state officials or federal officials. In the case of Tongo versus User, defined that everyone is operating under the color of law. We have a video called Know Your Rights, where we discuss
set up for failure, man.
Who and what happens under the staff for the color of law. You may preview that as well. So let's look at suspension of license, which falls under the statute 22 CFR 51.70. Here is where the guidelines for the suspension of your license. We have found through our research and determination that this is a constitutional challenge. In the case of Calvin Das versus Department of Motor Vehicle, which was decided in 2019 of January, where the justice ruled that the automatic suspension of your driver's license falls under the 14th Amendment for the due process violation, and therefore the 11th Amendment immunity is unavailable. If you have questions on this particular case, I've reviewed it in other videos, but feel free to send us an email.
So if they
We think this is the landmark case and the example for anyone who have lost their license and would like to get it back. You could use the brief, pretty much a blueprint in which to sue the agency.
How to achieve snacking.
So let's continue with the enforcement of arrears under 45 303.51. The lottery offset and state and federal tax refund offset. Again, the guidelines are the same. If you've accumulated more than 4 months of missed payments, they will use the offset of your tax return in order to pay it back. The drastic measure in the enforcement is the fourth option, which is called incarceration or failure to pay child support obligation. Now, this is a federal statute, and it falls under 18 U.S.C. 228. And here are the guidelines. If you have an overdue payment longer than 1 year or an amount exceeding $5,000, this is considered a criminal felony, and therefore you could be fined or faced up to 2 years in prison. The prior rule on this, it used to be 2 years of arrears as well as $10,000. So the legislators got together, the agency, and decided that they were going to reduce the requirement in order to force more enforcement of the law. So while this is happening, here comes a Supreme Court case. The case is called Turner versus Rogers. It was decided in 2011. The Supreme Court says there's a guideline question here. If the states now has the right to prosecute under this statute, but their attorneys are funded from the Title 4D program, then a due process consideration under the 14th Amendment must be considered. That is, that if the office or the state has legal counsel, then they should also consider legal counsel for those fathers. And again, the case is called Turner versus Rogers. Every state charges interest on their arrears. We've looked at all the 50 states, and we've reviewed and accumulate and recognize that they vary. The interest rate could be anywhere from 6% all the way up to 15%. We found that about 32 state charges over 10%, and maybe 1 or 2 state charges 0%. So let's take an example of a few states and look at how they break down their interest rate calculations. So let's start with Arizona. Arizona charges a 10% simple interest per annum, which is yearly, for the arrears. However, they reserve the right in which to change that. They could charge interest on the principal, which is the amount of the arrears, as well as they could charge compounding interest. Now, the statute that covers that under Arizona is called the ARREARS. It's the largest amount of arrears which cannot be removed by the courts. This is why, in our opinion, in my opinion, you can sue the support manager for fraud. In the case of Owen versus City of Independence, the justice decided that the 11th Amendment immunity does not apply. The reason is he's not a judicial officer. Next, the imputed income and the arrear calculation is all make-believe. It is fraud. It is fake. They're tasked with making sure that fathers basically pay as much as possible and beyond, knowing that the arrears cannot be eliminated.
So, what do you think about the G?
Now, all of this we said in a video called The 5 Lawsuits on our channel. You will see that, and where you could sue the Department of Motor Vehicles for unfavorable arrears, as well as you can sue the support magistrate. So this brings us to what is called our call to action page. And here's what my suggestion is. 1, review the Department of Justice letter as well as the deprivation of rights letter form called the COL. Contact your employer and request all documents related to deductions or deduction from your income withholding. Once you have that, review your statements and calculate your arrears and to determine if the correct interest rate is being applied. If it's not, then you have either a case for a lawsuit for fraud, or you can file a petition or a motion in which to reduce or apply the correct arrears or percentage. Next, you could follow the formal process, that is to attempt to eliminate those arrears. Unfortunately, as we've said, in the Docs case, it's very hard. The justices are not willing to do so. And then finally, if you'd like to know all the interest rates for other states that we have not reviewed in this video, please send us an email and we'll be happy to provide that information to you.
There go his channel right here, y'all. If y'all want to get over there and support his channel, get some more content. See what videos pop up. Last video was a month ago. But y'all can get over there, sub to his channel, and check him out. Peace.